a referendum. As discussed above, in this fresh impetus, it was agreed to harmonize all the previous drafts with only issues identified as contentious being reopened for discussion. After the establishment of the Committee of Experts in February 2009, the Committee of Experts prepared the revised harmonized draft, which was handed to the Parliamentary Select Committee on Constitutional Review. In this draft, the clause featured under Article 238, titled Amendment by the Popular Initiative, and the relevant clause was worded as follows. An amendment to this Constitution may be proposed by a popular initiative signed by at least 1 million registered voters. What comes out from this historical discourse is that the popular initiative clause fell among the non-contentious issues as it features substantively unaltered in all the draft of the Constitution. We also note that the drafters of this clause intended that it be invoked by the citizens, registered voters, and civil society groups as opposed to government institutions and officers. Whereas the civil society groups did not find their way into the final documents, the originators were retained as the registered voters, thereby maintaining the original intention that the power to initiate constitutional amendment by way of popular initiative was exercisable only by the voters. The clause, as it appears in our Constitution, bears resemblance to various clauses in constitutions of other countries on this issue. These countries include Switzerland, Moldova, Venezuela, and Liechtenstein. We have reproduced what it is explained to be in Wikipedia. Going by that definition and comparative jurisprudence, amendment of the Constitution through popular initiative cannot be undertaken by the government when it is the same entity that is being compelled to undertake the amendment, and in default, the amendment to be subjected to a referendum. It is therefore clear from our constitutional scheme that there are two ways in which a constitutional amendment can be initiated, either by parliamentary initiative or by popular initiative. The said provisions are in sync with the provisions of Article 1, Sub-Article 2, or Clause 2 of the Constitution, which provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Since Article 2, Clause 2 of the Constitution, under Article 2, Clause 2 of the Constitution, no person may claim or exercise state authority except as authorized under this Constitution. It necessarily follows that, subject to what we have stated elsewhere in this judgment as regards the role of primary constituent assembly, there is no other constitutionally permissible avenue available to any person to initiate a constitutional amendment save by the prescribed ones, parliamentary and popular initiatives. We shall come back to this issue in due course. We now proceed to deal with the question whether the Constitution Amendment Bill falls within the initiatives contemplated in Chapter 16. It is not in doubt that via Gazette Notice